You have questions, we have answers. Back with another quick clip. My name is Brian Leitner, and today I'm joined by Lindsey Hart McCool, a senior wealth advisor in our Tulsa, Oklahoma office. Lindsey, thanks for being here today.
Thank you, Brian.
So Lindsey, a question that was brought forward to the show is that, this individual, they're trying to think about opportunities within inside of their estate plan based upon some of the changes that have recently happened as it relates to the Secure Act and the CARES Act. These are two major pieces of legislation that have come out over the years, and wanted to know your thoughts on what you'd like to share today.
Sure. I think the first thing I'd like to share is just where we've had so much volatility in the markets. Now is a good time to be looking at gifting assets to those loved ones. Right now we have the taxable estate level is at $11,580,000 for an individual and $23,160,000 for a married couple. And while most people's assets are below those levels, there are several families out there that are above those levels and need to start looking at gifting while they can without having to pay the estate tax.
Yeah.
And that sunsets in December 31st of 2025. And it goes back to $5 million for an individual and $10 million for a married couple indexed at inflation. And you can also gift $15,000 annually to anyone that you'd like without any gift tax.
So $15,000 to anybody, to as many people as you'd like. And if you're married, can you double that?
Correct, you can. So that'd be $30,000.
Okay, so from a gift splitting perspective, and you're right, the estate tax today doesn't impact a lot of people, but for those that it do, it can be absolutely significant. And I always like to tell people that the big difference between the estate tax and estate planning, right? Estate planning is for everybody. But to your point, there are a lot of folks now, there are a lot more folks that might be impacted as it relates to the estate tax because of some of the changes that are slated, like you mentioned.
Right.
So as it relates to the environment that we're in, you think about interest rates and so forth and estate planning. We're in a low interest rate environment. What does that mean as it relates to potentially gifting and maybe avoiding estate tax?
Absolutely. So right now we're in a historically low interest rate environment, and there's several estate planning tools that are out there to help families transfer assets down the generations. One thing that we've found several clients that have wanted to do is to set up family promissory notes where maybe the parents are then transferring some assets through a family promissory note to the children and kind of taking that back in a note format. We also find that there's other individuals that are looking to leverage other estate planning tools like grant or retained annuity trust and installment sales.
So these could be pretty simple, just loaning your kids money, but making sure that you're doing it through the right channel and charging a given rate of interest.
Correct.
Or transferring maybe significant wealth with some tax maximization strategies as it relates to leveraging trust planning and so forth. Is that accurate?
That's correct.
And then, outside of the low interest rate environment, we've had some changes in the tax law as it relates to the Secure Act, the CARES Act, especially around retirement accounts and retirement planning. Can you speak to us a little bit about that?
Sure. The previous strategies we talked about are really more for those families with significant wealth, but what happened with the Secure Act impacts many of us. And previously, we were able to stretch retirement plan distributions over a beneficiary's lifetime. But now there is a 10-year payout on those retirement plans, except unless you fall underneath 5 categories under the eligible designated beneficiary section. So it's important to work with your estate planning attorney to help make sure that your trust is worded correctly so that those distributions can be taken out over a longer period of time.
So just to reiterate that, you used to be able to take out distributions as the beneficiary who inherited an IRA. Maybe it was, the son or the daughter over their entire lifetime, which could be 40, 50 years. And now it's over a 10-year period of time.
Correct.
And ultimately, taxes are going to be paid on those assets if they've never been taxed before. And that gets added as ordinary income, again, just simply under this 10-year period of time. So that might obviously spike the beneficiaries' income tax rates without any additional planning. Is that an accurate statement?
That is correct.
So some real things to think about as it relates to, folks, their own retirement plan, as well as their estate plan, because there are some individuals that, they have their trust as a beneficiary of their IRA and the language that's inside of there. This would absolutely impact them. So a great time to go ahead and review not only your overall financial planning situation, but obviously your IRAs, your estate planning documents, and so forth. Lindsey, greatly appreciate you being here. Thanks for joining the show today.
Thank you, Brian.
And if anyone would like to email us questions they have, they can feel free to email us at qa@marinerwealthadvisors.com. Thanks for watching.